Uh, for the continuation of our work, I'm glad to present Mr. Kieran Bradley. Kieran is at the moment a judge at the European Union Civil Service Tribunal. Before that, he had a career with various EU institutions and also a teaching career, as far as I understand. His topic today is applying EU law, the Charter, and other instruments. I am certain we will have a very interesting presentation, so not to steal any of your time, please, Kieran, go ahead.
Is this working? Good morning.
No, it is not, but I can switch it on if you want.
Well, it's up to people at the back. Can everybody hear me? Guy, can you hear me? Good. Okay, well, I'll do without the microphone then, and I'll follow Alistair's example and show you that summer is nearly here, at least in Ljubljana. So, when Andre and I first discussed the topic of my presentation, he had suggested that I deal with the interpretation of non-binding instruments in European Union law. Now, I have to say I was a bit reluctant because I thought the topic might be a bit of a slippery fish. So the compromise we agreed on was that I would deal with the Charter, which is a topic I think is of very great importance, and I understand you spoke a little about the Charter yesterday. But I would also deal with non-binding instruments as a sort of introduction. And I have to say I'm very glad I did, in the sense that there are certain common features between the two subjects. And the common features are, first of all, things are not always as they may seem from the text. And secondly, and you'll hardly be surprised for this, there is usually, and I would say even always, a good reason for the sometimes surprising results that the Court of Justice has reached in this regard. Now, I will start with non-binding instruments, and I have selected 5 recommendations, directives which are not yet in force, declarations by the legislature, unilateral declarations by member states, and national laws which apply to the which apply European Union law, as it were, ex proprio motu. Now, you might assume that the first 2, recommendations and directives which are not yet in force, have no binding force, while the 2 types of declaration might be considered relevant for the interpretation of union legislation, and that the court would have no jurisdiction to interpret national law applying European Union law as by a kind of renvoi. Now, if you thought that, I'm not saying anyone here did think that, you would be wrong on all counts. I'll start with recommendations. Recommendations, the primary characteristic of a recommendation is that it has, according to the treaty, no binding force. And yet, in a case called Grimaldi, and you've all the cases in the list that I sent, the court said 2 things. First of all, to understand what the character of a measure is, you must look at its content and not its title. That's standard European Union law. Perhaps slightly more surprisingly, the court said, national courts are obliged to take account of recommendations where they cast light on the interpretation of national measures which are designed to implement them. I'll explain why in a minute. Now we come to directives which are not yet in force. As you know, directives are adopted and the member states are given a certain period, 18 months, 2 years, 3 years, to bring national law into conformity with the directive. In the case of Inter-Environnement Wallonie, the European Union had adopted a directive which was to come into force in 1993. In 1992, the Belgian legislature adopted a measure which seemed to go the opposite direction. If you'll excuse me a second, I've got to find my notes on that. I have a problem of so many notes here for you all. This is what I did yesterday rather than coming here. So. Okay, thank you. So, yes, the Union adopted a directive setting out a permit system for treating certain types of waste. It allowed an exemption from that permit system under certain conditions, and as I say, Belgium adopted, and it wasn't Belgium the state, it was the region of Wallonia in Belgium, which adopted a rather contrary measure 1 year before the directive was to come into force. The court was asked whether the member state had any obligations under the directive before it was supposed to come into force. The court held, first of all, the binding effect of the directive applies to all national authorities, including the courts and including the regional legislatures. Of course, a member state may not be faulted for not transposing a directive early. That's obvious. However, between the adoption and the deadline for transposition, member states must refrain from taking any measures which would seriously compromise the result prescribed by the directive, and that it was up to the national court in each case to decide whether this was so. The court then identified a number of relevant factors. Did the national measure purport to constitute transposition? What were the practical effects of the national provisions? How long were they supposed to be in force? Would it be possible to amend them in time? How did the court reach this conclusion about recommendations and directives not yet in force? And the answer is to be found in Article 4.3 of the European Union Treaty. Not the Treaty on the Functioning of the European Union. It is Article 4.3 of the European Union Treaty, which lays down a fundamental principle. And the principle is, one of the aspects of the principle is that member states shall refrain from any measure which would jeopardize the attainment of the Union's objectives. It is a principle of, if you like, sincere cooperation between the member states and the European Union, a bit like the idea of Bundestreue in Germany, so-called federal loyalty. And it creates a sort of mindset that the member states must adopt vis-à-vis the European Union, which allows the court to say that in some cases they must take account of directives which are not yet in force and recommendations. The other side of the coin is declarations by the legislature. I understand that under public international law, declarations adopted by, as it were, the bodies signing up to a convention can then be taken into account as regards the interpretation of that convention. In the case of Antoniessen, the community legislature at the time adopted a very restrictive interpretation of a treaty provision on free movement of workers, which was then relied upon by the United Kingdom government in interpreting that particular piece of legislation. The court was very blunt in dismissing the possibility of relying on such a declaration by the legislature. The court said, the Council declaration cannot be used for the purposes of interpreting a provision of secondary legislation where there's no reference made to that declaration in the wording of the provision. And of course, if there's reference to the declaration in the provision, you have a legal basis for taking account of the declaration. Otherwise, the court said, the declaration has no legal significance. The court was equally, if not more blunt, in rejecting the possibility that a member state declaration, a unilateral declaration by a member state, should have any legal effect. And indeed, in the famous Dufresne case, I didn't mention it, the court also said that a resolution of the member states adopted unanimously that they would postpone the coming into force, or the effect, should I say, of a particular treaty provision. And the court said this was not, this resolution could have no legal effect on the interpretation of the treaty.
Sorry?
Yes, please.
Do you have the case number there? Because I think we know, we are familiar with the cases, but the last one.
The Dufresne case, it's the second. Dufresne, exactly. You probably know Dufresne, but as we're dealing with as it were non-binding instruments, the court, as I say, has always been fairly blunt. So, the reasoning of the court as regards these types of declarations and indeed the resolution is slightly different. It's based on the idea that European Union law acts directly on the individuals, and you cannot have member states intervening and therefore, as it were, watering down the rights of individuals or in some way impacting on their legal obligations under the treaty, and it goes back to the Van Kent and Loos decision. I won't deal with the question of the slightly more complex issue of where a member state voluntarily applies European Union law to a situation which falls outside European Union law. Alistair might want to deal with it if he wants. It's to do with the jurisdiction of the court in preliminary rulings, but the relevance for us is that where the court interprets a national provision, as it were, which applies European Union law by renvoi, that interpretation would, in theory, then be binding on all the other member state courts. Because what the court is doing is, the national law has a renvoi to European Union law. When the court interprets the European Union law, then that interpretation is binding on all the national courts, because that is the raison d'etre for the court to accept jurisdiction in that particular case. So that's as regards non-binding instruments. I'll now move on to the Charter, and after my little introduction, you'll probably be expecting me to say that as regards the Charter, it doesn't always say what it means, or perhaps it doesn't always mean what it says, and you would, in fact, be more than partly right. Now, the Charter is a very vast subject, which has spawned a huge and, I have to say, highly enlightening academic debate, and indeed debate between judges from various courts. For this morning's purposes, I will only deal with 3 topics, which I hope will be of interest to you as national judges and law officers in the member states. The first subject is the application of the Charter to the member states. I think you've spoken a little bit about Uckerberg-Franzen yesterday, but I'm sorry, we're going to have to deal with that again. It's a major topic, and I have some views which I hope you won't have heard before. The rule, of course, is set out in Article 51(1) of the Charter, where the actual rule as drafted says the Charter shall apply to the member states only when they are implementing union law. And at the same time, Article 51(2) reminds us all, because it's elsewhere in the treaty as well, that the Charter does not extend the powers of the Union in any respect. Or indeed, now this is perhaps more important, it does not extend the field of application of union law. The second topic I need to deal with is the level of protection and the interpretation of Article 53 of the Charter, which says in essence that the member states may apply a higher level of fundamental rights protection, where it can apply fundamental rights protection as guaranteed by their own constitutions. And we'll see that needs a certain qualification. And the third topic is one of the more general impact of the Charter, where the member states are exercising options under European Union law. And that is illustrated in particular by the NS case. I don't know if people have had the chance to read that, but I'll talk about it somewhat. So, the first topic, the application of the treaty only where the member states are implementing law. You can say that this is the chronicle of a dispute foretold. There are two, if you like, possible, two major schools of thought. One is what you might call the agency situation. In other words, the member states are only obliged to apply the Charter when they are transposing directives, when they are applying regulations, applying directives, decisions, treaty provisions, and so on and so forth. If you like, a sort of direct implementation of a clear provision of European Union law. That's one interpretation of the expression implementing. However, the explanations of the Charter, and by the way, under the text of the Charter itself, the courts are obliged to take these explanations into account, or rather, they're obliged to give due regard to the explanations. The court has never explained what due regard means, but in any case, certainly taken into account. The explanations say it follows unambiguously from the case law that the requirement to respect your union fundamental rights applies to member states when they are acting within the scope of European Union law. And the difference is illustrated by an old case, the ERT case. In the ERT case, Greece was granted a monopoly to a television company, the national television company. I don't know what it's called. It's probably called ERT now that I think of it. And the question then arose if whether this is perfectly in line with European Union law. The question arose whether when Greece was applying this monopoly, it was required to take account of fundamental rights, and the particular fundamental rights there was the right to freedom of expression. Now, it's clear that these monopolies may not breach European Union law on, for example, free movement of goods and services, or indeed competition. Now, the idea of, as regards competition, I was thinking, if you give them a monopoly, how can you say that there isn't an impact on competition? But the impact is you give them a monopoly, a dominant position, which they may not then abuse. So the question in ERT is, it's clear under ERT that the member state was not acting, was not implementing Union law. It was clearly not implementing European Union law, and yet it was acting within the scope of European Union law. And in those circumstances, the court said that it must comply with European Union fundamental rights law. So now we come to Åkerberg-Fransen. Do I take it that everyone knows the facts of Åkerberg-Fransen? Yes.
There was a long discussion yesterday.
Okay. So I won't go into any details as to what the court, the background. You know that the court said that the Article 51.1 of the Charter confirmed the pre-Lisbon case law. Fundamental rights apply to the member states when they are acting within the scope of European Union law, etc., etc. This gave rise to a great deal of controversy. I presume many of you know about that in any case. Or should I say, I don't think one should exaggerate the extent to which it's controversial. It's certainly controversial in the German Federal Republic. 2 months later, the Bundesverfassungsgericht went out of its way to indicate its how unhappy it was with the Åkerberg-Fransen decision, at the same time as it refused to send a reference to Luxembourg in a case which arguably did give rise to a question of that the Court of Justice should be asked to deal with. Now, the court said that the German federal courts, the federal constitutional courts, said that the Åkerberg-Fransen case was confined to the specific features of VAT law, and even hinted that in its view, Åkerberg-Fransen could be considered ultra vires. Ultra vires is a criterion that the Bundesverfassungsgericht regularly uses as a means of warning the Court of Justice, watch out, you're coming close to what we can accept here. I should point out that other Supreme Courts are much less unhappy with Åkerberg-Fransen. As I understand it, the United Kingdom Supreme Court had adopted a fairly similar view to the Court of Justice even before Åkerberg-Fransen, and the Dutch, or at least not the Dutch Supreme Court, the Dutch courts all reached a similar conclusion. And as I understand it, I don't know if someone's here to correct me, but the Austrian Constitutional Court had adopted a similar position a year before the Court of Justice. So there is some level of discontent in one member state, but that does not amount to a general feeling of revolution against the Court of Justice. Now, what I would like to do is then deal in a little more depth what Åkerberg-Fransen means in practice. In practice, you've got to look out for what you might call a triggering rule, a rule that will set off an obligation for the member state to apply the Charter. And in the literature, 3 types of rules have been identified: mandating rules, rules giving options, and rules concerning remedies in the member state courts. Mandating rules are fairly simple. It's where the European Union gives the member state an instruction to carry out a specific activity. And Åkerberg-Fransen is in itself a good example of a mandating rule. According to the rules on VAT, the member states are obliged to collect VAT and combat fraud. The court added a more general mandate, and I have to say that it's a little more difficult to as it were, limit. The court added the general requirement on the member states to counter fraud affecting the financial interests of the union. And I think the court did that in order to say that you may not have a specific legislative provision that says you have to do X. There may be a more general provision under the treaty, which also, as it were, triggers the application of the Charter. Now, the court concluded that the tax penalties and the criminal proceedings constituted implementation, even if the national measures had not been adopted with the specific purpose of applying VAT and protecting the European Union's financial interests. How do you recognise a mandating rule? The use of certain language, in particular. Shall, will, must, or even, depending on the context, the indicative. The member states take a certain action. So, that's the first category of triggering rule. The second would be rules giving options. And here we come to the very interesting case of NS. Now, NS concerns asylum, and I know there are people in this room who know a great deal more about asylum rules than I do. Can you tell them I'm busy? So please forgive me if my presentation of the asylum rules is a little sketchy. In any case, one of the things the common asylum policy does is it identifies which member state is responsible for dealing with an application for asylum. It also gives another member state, presumably the member state in his jurisdiction the person finds himself, gives them the option to become the member state responsible. So you've got a collection of rules which determines which member state is responsible, but you also have the option for any other member state, presumably with some kind of connection, to become the member state responsible, in which case the obligations of the regulations, there's collection of regulations, apply to that member state, and that is by virtue of the so-called sovereignty clause. Now, I won't go into the details of NS, or will I? No, I won't. I have to say a little bit about the circumstances of NS. NS was an Afghan refugee who first of all came to Greece. He was expelled from Greece to Turkey. He was detained in Turkey and then he escaped from Turkey. It reminds me of Midnight Express. I mean, we don't know what the circumstances are, but he escaped from Turkey and he ended up in the UK. So the UK said to Greece, look, we have this man, it's clear that he entered Greece, so in principle you are the member state responsible, please take him on. And I should also say that for the purposes of these rules, Greece is considered a safe country of origin, which lessens the obligations of the United Kingdom. They can, as it were, assume that Greece is a safe place to send him back to. So, NS asked the United Kingdom to take responsibility for his case. The Home Secretary refused, and it was the decision of the Home Secretary to refuse to take responsibility for NS, which was reviewed in the British courts. So the question put to the Court of Justice is, does a decision not to exercise an option, as it were, attract the application of the Charter? Several of the governments said that the decision was outside European Union law. The sovereignty clause was not a derogation, as in the ERT case, and exercising optional responsibility does not, as it were, implement European Union law in the sense that it's an option. They're free to do it or not to do it. And they argued as well that the rights of the individual would in any case be protected under the European Convention on Human Rights and the Geneva Convention of 1951 on the status of refugees, to which all the member states are parties. The Court of Justice said, no, the sovereignty clause grants a member state a discretionary power. Now that discretionary power is an integral part of the common European asylum system. And when that power is exercised, in either sense, in other words, you exercise your option by saying I will not take responsibility, or you exercise your option by saying I will take responsibility, that option must be exercised in accordance with the other provisions of the regulation. The derogation from the rules determining the member state responsibility, gives rise to specific consequences, and the exercise of that option is part of the mechanisms of the system, and the member state is therefore implementing European Union law. So that's the second type of rule which triggers the application of the Charter, and the third are rules on remedies. Now, rules on remedies are actually fairly simple, in the sense that you're all aware the European Union doesn't have a federal administration. The member states are required to use their remedies, the national courts, well represented here this morning. National courts then enjoy what the court calls procedural autonomy under European Union law, but subject to a certain number of principles, the principles of effectiveness and the principles of equivalence. Equivalence means that a remedy for a breach of a European Union right must be equivalent, and the principle of as equivalent to the remedy that's available for a similar right under national law. And effectiveness means that the remedy available cannot make the exercise of the European Union right excessively difficult or impossible. So, when the national courts are applying remedies to European Union law claims, the national courts are, of course, implementing Union law. And, for example, Article 47 of the Charter, which deals with the right to effective judicial protection, comes into play. The matter is illustrated by one of the cases I gave you called DEB. It's an interesting case, but I can't say that the conclusions drawn by the court are very enlightening. DEB was a German company suing the Federal Republic for a vast amount of money under the European Union doctrine of state liability. DEB claimed that because Germany had not transposed a certain number of energy liberalisation directives into national law, it had been deprived of profits of something close to €4 billion. Now, DB had no assets. It had no employees. It had no creditors. And as a result, it was unable to make the advance payment to the court in order to initiate its court action. It applied for legal aid, and it was refused legal aid on the grounds that, as a legal person, the requirement was that there should be a public interest in the continuation of the case, and the courts decided that there was no. The courts decided, on the one hand, that there was no public interest, and therefore they didn't get any access to legal aid. On the other hand, the court, I think, very correctly said, does this cause a problem with regard to Article 47 of the Charter? In other words, here you have a situation where these people can't go to court. They have a European Union claim. They can't go to court because they have nothing, as it were. They can't even start their action. Does that mean that they are being deprived of effective judicial protection under the Charter? Now, Article 47.3 of the Charter actually says legal aid shall be made available to those who lack sufficient resources, insofar as is necessary to ensure effective judicial protection. One interesting aspect is that the court hadn't at the time very much case law on effective judicial protection, largely because it was something that had been mentioned in the case law of the Court of Justice. However, the effective judicial protection is something that is in the European Convention of Human Rights, and the Court of Justice, the Court in Strasbourg, has a very vast case law on effective judicial protection, which the Court of Justice then relied upon to interpret the Charter. The Court of Justice said, on the basis of this, that legal aid in the Charter is not conceived as being an element of social assistance, as the Court said was the case in Germany, but rather a matter of access to justice. So the determining factor is the situation of the claimant and not some sort of public interest. So in other words, the Court of Justice said to Germany, you may not, if you're going to apply the Charter, you have to apply the Charter, and you must, as it were, adopt a different view on what the purpose of legal aid is and how to get the conditions under which people can get access to legal aid. The court said, and this is where the answer of the court is a little less enlightening than it might be. The court said it is not therefore impossible for a legal person, a company, to get access to rely on the right to judicial protection, but it is up to the national court to decide whether the conditions for access to that legal aid are fulfilled. So, wow, I think I have completely bamboozled you. If you have comments and questions on this, I'm more than happy to answer them. In the meantime, I will move on to the second major topic, which is the level of protection which the member states' courts must, or the level of protection which member states can allow or guarantee under the Charter. So you assume the Charter applies in a particular question. Can a member state apply its own level of protection where it considers that as higher than the Charter? Article 53 of the Charter says nothing in this Charter shall restrict rights or freedoms recognised in the member state constitutions. The question is just not so clear-cut as we can see from the Maloney case. It's Maloney with two L's, O-N-I, rather than Maloney, the famous Irish name. So, the question in Maloney is, could the Spanish courts apply their obviously higher standard of protection for defendants in a criminal trial who are the subject of an arrest warrant, a European arrest warrant? Under Spanish constitutional law, surrender would be refused if a person is convicted in absentia and then does not have the possibility of challenging that conviction in the issuing member state, so Italy. The Spanish Constitutional Court said this gave the member states a general authorization to apply the level of protection that arise from their fundamental rights and give this priority over any conflicting European Union law. Therefore, the Spanish courts would be able to make surrender conditional on the possibility of Mr. Maloney challenging his conviction in Italy, because Mr. Maloney had been convicted in absentia. Now, the court, first of all, stated its classical view on the primacy of European Union law, even saying that even a constitutional provision of a member state may not defeat the effectiveness of European Union law in that state. It then went on to point out that the framework decision on the European arrest warrant had been amended in 2009 expressly to deal with the position of those who are convicted in absentia. Clearly, the problem that Spain had raised had been a problem which had not been dealt with in the original version of the framework directive on the European arrest warrant, but the legislature got around to dealing with it in 2009. And applying the European arrest warrant as it then stood meant that Spain would not be able to apply its constitutional provisions. The court said that allowing Spain to go alone and therefore refuse the surrender in this case would cast doubt on the uniformity of the standard of protection and undermine, and I quote, the mutual trust and recognition which is at the basis of all these matters of justice and home affairs, and compromise the efficiency of the framework direction. Now, did the court get it right? I would suggest to you that the court did get it right. Article 53 of the Charter is a provision of European Union law and has to be interpreted in the light of the specificities of European Union law. If I might quote from the Advocate General, in this case, he said, "The choice of human rights and the level of protection in the framework decision reflects the choices of society as regards the proper balance between the interests of the individual and those of the community to which they belong." Now, in the case of the European arrest warrant, there is a link between the approximation of laws. And as I say, in 2009, with the amendment, the laws were approximated even including this aspect of convictions in absentia. There's a clear link between the approximation of laws and the enhancement of the mutual confidence between the member states. Article 53 therefore complements 51 and 52 by showing that the Charter is not intended to become the exclusive instrument for fundamental rights protection. I have to add that given that the Charter the protection of fundamental rights was introduced in the European Union legal order in late 1960s, early 70s, in order to protect the primacy of European Union law, it would be rather ironic if the Charter were allowed to undermine that protection 40 years later. So, that's as regards the level of protection. Yes. And then the third matter I want to deal with is a sort of general impact of the Charter on the if you like, hidden obligations for the member states that arise from the Charter. Now, yes, in NS, what the Court of Justice did was it, in effect, allowed, or rather required, the United Kingdom to see whether the fundamental rights of NS were going to be respected when he went to Greece. Some of the member states said, but how do we know what the conditions are like in Greece? And the Court of Justice pointed out to the European Court of Human Rights, which at about the same time as the facts giving rise to NS, the European Court in Strasbourg had decided that the surrender of a group of people, or a person or a group of people, by Belgium to Greece, given the particular conditions in Greece, the court was very, I think, correct regarding Greece. The court said that whereas the asylum system depends on a certain number of, if you like, presumptions, the presumption that a member state is able to deal with and does deal with applications for asylum properly, that is not an absolute presumption. That presumption can be overturned, and the member states had certainly sufficient information concerning the situation in Greece to know that there was a problem with Greece. There are three considerations where I think the court took into consideration. One is Article 4 of the Charter. Article 4 of the Charter, which says no one shall be subjected to inhuman or degrading treatment, is one of the very few Charter rights which is unqualified. Secondly, it is equivalent to Article 3 of the European Convention on Human Rights, and like Article 3 benefits everyone within the jurisdiction of the states which are parties to the European Convention, and by analogy you can say NS in the United Kingdom could benefit from the application to it by the United Kingdom of Article 4 of the Charter. The conclusion then is, as regards NS, in a union which is founded on common values, member states are indeed their brother's keepers. And as you all know, under Article 259 of the Treaty on the Functioning of the European Union, one member state can actually take legal proceedings against another member state where that member state is not applying European Union law, and I would suggest could even do so if the failure to comply with European Union law arose from the Charter. I'm coming very rapidly to my conclusions and giving you plenty of extra time. Why was the court right in the Franzen case? Or Ockerberg-Franzen, I should say. First of all, the approach adopted by the Court of Justice is clearly consistent with the wording and the purpose of the Charter. That is to say, if the authors of the Charter had wished to narrow the scope of protection for European fundamental rights, and therefore, as it were, overrule the ERT case, surely they would have said so in unambiguous terms rather than leaving it to this term implement in the text and scope of application in the explanations. More significantly, The Charter seeks to make the European Union fundamental rights more visible and more effective for the individual. How could then the court say, we'll go back to application of the Charter in the Member States to the agency situation? That would certainly run counter to this objective of making the Charter more visible and more effective. But there is a final argument, which for me is a smoking gun. And as a judge, I'm always on the lookout for a smoking gun. I can go home happy when I've found a smoking gun which determines the case one way or the other. Now, and that smoking gun for me is Article 4, Paragraph 3 of the Treaty on the European Union, the so-called duty of sincere cooperation. This also says not only that Member States shall refrain from taking any measure which would run counter to the achievement of the objectives of the Union, it also says, and I quote, Member States shall take any appropriate measure, general or particular, to ensure the fulfilment of their obligations under EU law. That means that when Sweden was prosecuting Mr. Åkerberg Fransson for VAT fraud, it was implementing European Union law. It was implementing, at the very least, Article 4, Paragraph 3 of the European Union Treaty. And therefore, the Court of Justice is obliged, because of its general duty to ensure the law is respected, it is therefore obliged to apply the Charter to that particular action. Now, I think it would be somewhat imprudent for me to say that the controversy over Åkerberg Fransson is a storm in a teacup. But I just wonder if the matter hasn't been, the importance of the matter hasn't been exaggerated somewhat. After all, the argument of the Bundesverfassungsgericht amounts to saying that they don't want to apply a Charter of Fundamental Rights which was drafted by the European Union on the express suggestion, not to say the express instructions, of the very same Bundesverfassungsgericht. When they know that in 99 cases out of 100, they will in any case be able to apply any higher standard that applies under German constitutional law. Now, as regards the level of protection, Maloney was a very exceptional case, where the application of Spain by Spain of its notion of a fair trial would have undermined the very possibility of applying the European arrest warrant. In other words, the European arrest warrant was based on the idea of mutual trust, and if you allow one member state to go ahead, then you turn the whole, you deprive it of all, as they say, as we like to say, effet utile. It would have allowed Spain to import its, or rather to export its ideas of constitutional protection to Italy, which has a different idea, and it's Italy's idea, which happens to be to correspond with the text of the European arrest warrant. I mean, it's a question of, as Paul Simon used to say, one man's ceiling is another man's floor. That's the way. So, and the last thing is, as I said, NS, on the other hand, is, if you like, the converse of Meloni, where the United Kingdom was required, it didn't require the UK to impose its own thinking on constitutional protection, but it did require, the court did require the United Kingdom to ensure respect for the Charter in a very particular set of circumstances, even where normally the United Kingdom would have an option to simply say, we don't need to deal with this asylum application. The common theme of all these situations is that the Court of Justice is striving to make European Union law in general, and the Charter in particular, a reality by taking, if you like, a holistic view rather than being confined in every case to a literal reading of the texts. Thank you very much for your attention. You've been most...
Thank you very much for your very comprehensive presentation. Are there any questions?
Or comments?
Yes, please.
Yes, I have a question on legal aid, because I mean, I'm from Sweden.
Mm-hmm.
So you pronounce it perfectly.
I will say I worked hard. I looked up, I googled how you pronounce this little A with a...
Right. No, but concerning legal aid, as in Sweden, I work also the last instant in migration issues. So if a person comes to Sweden and applies for asylum, he or she will have access to legal aid instead of being paid for a counselor. Whereas if the person has been granted a residence permit and then would like to have some family members come in, we won't allow them and legal counsel, legal aid. But right now, so now we have the charter. Are we supposed to? That's of course. I mean, it's a question of if the person needs access, of course, needs access to justice, but also if they can't afford it by themselves. And I would say that, well, people can afford some legal assistance. So how should we do that?
You're surely not asking me to give any judgment on how Sweden should apply Article 47. But what I would say, of course, is that there is nonetheless an obligation on Sweden to examine the necessity to apply legal aid in these circumstances. Just to get back to NS and the right to effective judicial protection, one of the peculiarities of that case was that in the NS case, the Home Secretary certified that NS was to be deported because he was going to a safe country of origin. And under British law, and again, I'm ready I stand to be corrected if I get this wrong. I understand he didn't even have a right to contest that decision, and it wasn't until the Home Secretary withdrew the deportation order that he then had the right to challenge it. But I have to say, I thought it was very fair of the British system to allow someone who, for most of the proceedings, had no possibility of contesting his deportation order, was not deported and was able to go to the British courts and, as it were, get effective judicial protection in those circumstances. I thought it was.
Perhaps they applied the Dublin regulation because
Well, I wouldn't know.
You have the right also under Dublin too to contest the decision.
Right.
But you're perhaps not allowed to stay in the country as.
That's it. I mean, there was a danger that right up to the last minute, the day that the deportation order was to take effect, was the day that the Home Secretary said, "Okay, let's leave him here in the United Kingdom, and then we'll deal with his legal problems." I thought it was very fair.
Okay. Any further questions? I would ask you more than for. A further comment on a topic than it is a question, namely, you have mentioned what I like very much, a storm in a cup of tea, and this is what is actually the first idea that springs to mind, speaking of the Charter. Now, this is a catalogue of basic rights that is 40 years old. Now, couldn't we reasonably expect that in most of the member states, this catalogue is already let's say, part of the standard of protection of basic rights by their constitutional standards. So what is exactly the, let's say, main problem in applying it?
As you will remember, of course, I said that it would be imprudent to say that Åkerberg Fransen was a storm in a teacup. So I didn't say that. No, I agree with you. The Charter is, nonetheless, I mean, there are two different things. One is, it is meant to be a codification of the fundamental rights, which were already in the case law of the European Court, which is, of course, one of the reasons that a narrow reading of the implementation criterion wouldn't be justified. Nonetheless, at the same time, you must remember that it's not quite 40 years in the sense that the European Convention in Strasbourg that was drawn up in the very early 50s. Here you have a catalogue of rights which was drawn up in more or less in 2000, and taking into account, I hope they were taking into account the progress that had been made. There are certain rights within the Charter which I think in the 1950s would never have been thought of. The right to human dignity and, well, I don't know about, no, not the right to human dignity, but bodily integrity and if you like, certain restrictions about scientific research that might affect, as it were, bodily integrity. But as to the idea, the question is what the main problem is. I think part of the problem is not that you don't have a proper, that you don't have a set of rights that all the member states can subscribe to, but you have 3 different sets of rights to which the member states can subscribe. And it gets worse before it gets better, because in the next couple of years, the European Union will itself accede, presumably, to the European Convention on Human Rights. Which means that whereas the court now uses the European Convention on Human Rights as a source of inspiration, once the European Union accedes, it will actually be bound once and for all to the European Convention. I don't think it should be a major practical problem, and if you talk to judges at the European Court, they will always tell you, yes, but we won't have a problem because we guarantee a higher level of protection in all circumstances anyway. But as to why, I mean, I'm not saying it's a storm in a teacup, but the circumstances under which a member state is not entitled to apply a higher standard are I would have thought, very unusual indeed. Maloney is a very particular example where, if you like, you had a very complete harmonisation of one aspect of dealing with asylum applications, and it just so happened that the UK, given the circumstances of the case, had to, as it were, assume responsibility. It also means that it shows that the court is open to the idea that member states will be able to apply, will have, as it were, a backstop. There will be circumstances where, regardless of what the rules say, the member states will be obliged to take certain options in order to ensure Charter. In other words, it shows that the Charter, the protection of fundamental rights, is more important in certain circumstances than the text of the Union legislation.
Could I make a slightly more general comment about human rights and charters and Strasbourg and all the rest of it? It's a slightly odd thing to say maybe, but in almost every area of law, of European Union law, even under the expanded Lisbon Treaty, you have a department, civil servants working on a daily basis on that area. For example, food law, for example, energy law, for example, external relations law. But human rights is slightly odd, and I in the sense that there is no specific individual or department in the European Commission, for example, with responsibility for dealing with human rights. It's the responsibility of everybody and nobody. And if you ask Barroso and the other 27 commissioners, what they think about human rights, you'll get a very general answer, which is that, of course, the European Union and its member states subscribe to the protection of human rights. And Kieran's absolutely right, of course. The Charter is a distillation, for the most part, of general principles of law recognised by the constitutional systems of all the member states. So it's not supposed to break new ground, really. I've always had a slight problem, I must say, despite all the explanations in relating the Charter to the European Convention. There's scope there for, legalistic argument of distinctions when there was no intention to make a distinction. But my point is that human rights in the EU still is a slightly immature subject. It's not dealt with in a coherent, consistent way. It's dealt with in an ad hoc way on a case-by-case basis, very often through the preliminary reference procedure, actually, because the Commission doesn't take infringement proceedings against member states on human rights issues, for the most part. At least I don't think so. I'm not aware of any. Anyway, I'm being a bit provocative because one of the things I'd like to achieve in the next hour and a half is to get you lot sort of talking more and firing questions and discussing, because but that's my sort of rather primitive view. I speak there from a Brussels standpoint, not a Luxembourg Strasbourg standpoint, okay? But I think that, as I'll say later on, I think the two standpoints are valid. Kieran, what do you think?
The idea that there should be, as it were, a human rights policy, a fundamental rights protection policy, is one that's been going around Brussels, Strasbourg, Luxembourg, well, Brussels, Luxembourg, perhaps not Strasbourg, for a very long time, and it was always considered that giving the European Union, even defining the idea of a European fundamental rights protection policy would lead inevitably, as it has in the United States, to an extension of the competences of the European Union. Yeah. And that is anathema to the member states. Yeah. Now, I don't think that thinking, the fear that fundamental rights competence would, as it were, expand substantive competence, is founded. There are two reasons. First of all, the Court of Justice said in an opinion in 1996 that although the institutions are obliged in all their activities to respect fundamental rights, that does not in itself create any competence. And that is why the court said at the time that the European community could not accede to the European Convention on Human Rights. It had no competence to do so. And that is why you now have a provision in the treaty which says the European Union shall accede to the European Convention on Human Rights. And the second one is much more fundamental. And it is that you must compare like with like. And the structures in the United States are very different from the structures in the European Union. The member states, the prime guardians of their own competence, are present in a way in the European decision-making structures in a way that the states of the Union, at least not now, are no longer. In the United States, you certainly have senators from the member states, but you have ministers, I should say, from the member states coming to sit in the Council of the European Union. You have working groups of the Council which are comprised of national civil servants. In other words, you have the national interest there as a daily aspect, a very important part, an essential part of the decision-making structures. And of course, at the end of the day, when you have treaty amendments, it's the member states that are in the driving seat. Yes, you now have you can have a convention which brings in national parliamentarians and other people, but the fact of the matter is that up until now, the member states have always been in the driving seat as regards treaty amendment and the adoption of legislation, adoption of policy generally, and the implementation of policy when it comes back to the member states. So the danger that there would be a significant competence creep simply because the Union protects fundamental rights, I think is again somewhat exaggerated. Now, to get back to your more specific point about there not being a particular department, I understand that there are instructions now. I didn't work in the commission. I know you did. There are instructions for all. I presume there are instructions for all the DGs that they take account of the charter. But I suppose maybe for individual DGs it might be a bit remote. On the other hand, there is the very excellent legal service of the Commission. I think the legal service of the Commission would consider part of their remit to, as it were, point out any possible problems with fundamental rights. And of course, you have the European Parliament, where its parliamentary committees are specifically charged. One of the many things they have to look at when they receive a legislative proposal is to check, again, compliance with the fundamental rights and now compliance with the Charter. So, of course, the European Union can adopt decisions and directives and regulations which breach fundamental rights. And there's a very stark example recently of the Data Retention Directive. The Data Retention Directive was adopted, I suppose, around the mid-2000s. It was challenged initially by Ireland, which said that the legal basis, it was an internal market measure, that the legal basis was wrong. I may be wrong, but I think it was Slovenia intervened to say, yes, and as well as that, it breaches the fundamental right to protection of personal data. Now, unluckily for Slovenia, the court said that was not an argument raised by Ireland, and therefore we cannot deal with it. So anything we say, and then the court upheld the legal basis. Some months ago, or even weeks ago, the court struck down this directive in very sweeping terms indeed. The court said that the directive went way beyond what was required for an internal market measure, strangely enough. And if you read the two judgments together, it's a little surprising. In fact, in this year's judgment, the court doesn't even mention the fact that the same directive had been the subject of institutional proceedings some years ago. Be that as it may, it's fairly rare, because there are lots of, as it were, guardians of fundamental rights within the European Union, member states, the institutions themselves. They have mechanisms. They are not perfect, but it's certainly not something that should go, as it were, unperceived.
Right. again, you weren't here yesterday afternoon, but there was a very interesting discussion about the possibility of conflict, notably between Germany, but also there's other member states as well, and Luxembourg. Who has the last word? Isn't it what we were talking about yesterday? And it's quite interesting because I think the EU system lends itself to that sort of dilemma, which the US system doesn't. And the reason for that is that in the US system, you have two structures, two court systems, the federal and the state court system. And it is the federal system, which is under the Constitution, which is responsible for the protection of human rights. Primary superior responsibility for protecting human rights is with the Supreme Court, ultimately, and the federal system. So there's a very clear hierarchy in the United States. We don't have that. The fact that our national courts are EU courts actually is the reason why we could have a conflict or a discrepancy between what the European Court of Justice in Luxembourg decides and what the Bundesverfassungsgericht decides, and who has the last words. We said yesterday after it's probably a question better not asked at this moment in time. Let's just coexist as best we can, based on perhaps a certain ambiguity, a certain amount of compromise. But that is very interesting. Listening to you this morning and thinking about this, that's where it comes from. Is the fact that we are a unified system of law with one set of courts. We don't have two parallel sets, but in the US they do. So it's absolutely clear that when Georgia does something which is contrary to Article of the Constitution, it's the Supreme Court of the United States which tells Georgia what to do, and that is it. End of story. But for us, we can create ambiguities for ourselves because of the court structure.
The question, but just kind of finish off with good.
In that scope of
Yep.
I don't think that there is any national judge, because you mentioned NS case in England, that will take responsibility and make a review on the Greek situation and said, the level of human rights protection in Greece is not quite good, so the asylum seeker will stay here. I'm not sure if it's so, but if I'm on the place of English judge, I will not do so.
The English judge was invited to take account of the situation in Greece, as had been not so much on his own motion, but given that certain information was available. Some of the member states said, yes, but how can we know what's going on in Greece? And it was in the very particular circumstances of the fact that at the same time as the facts of the NS case, you had the facts of the MSS case, on which the European Court in Strasbourg had given judgment in 2011, and therefore the English courts should have had or at least, shall we say, the authorities, the Home Secretary, should have had and could have had access to that information. Now, the court was very, very. I think the court tried to be very correct regarding Greece, and in particular, the court said, for example, that not every trivial breach of the already trivial problem arising, but the fact of the matter is, the Court of Justice said, look, we have evidence which all the member states have access to that there is a problem with Greece, and the court said, and didn't say it in these terms, but the court said, did take note of the fact that Greece received approximately 90% of the first entrance. So if Greece was overwhelmed, there's a good reason. And Greece had, I think, asked for the suspension of the system to allow it to deal with the situation. So I don't think there's, as it were, a criticism of Greece involved in that, so much as a duty on the other member states to, as it were, show solidarity with Greece. That's the way I read it. I mean, maybe you see it differently. But just to follow up something that Alistair said, I find it slightly. The more the union goes on, the more you get this question of who has the last word. And I was reading yesterday Article 4(2) of the European Treaty in the European Union gives. It says that the European Union, amongst other things, shall respect the equality of the member states as well as their national identities. But the problem with that is does that mean that what constitutes national identity is now a matter of European Union law? Was it necessary to put this in the treaty? In other words, there may be circumstances where what constitutes national identity for the purpose of European law is something that the European Court will have to decide.
I think, since I've been sitting here, something has struck me in a way which has not been the case for some time. Perhaps I spend too much time in Brussels and not enough time in Luxembourg or Strasbourg. But not everything in the treaty is justiciable. The Treaty on the European Union, much more obviously than the Treaty on the Functioning of the European Union, is a political document. Of course, I know it's a treaty, and I know it's ratified, and I know it's legally binding. If you take subsidiarity, okay, of course there will be an occasion in future when the European Court of Justice has to rule, and I know subsidiarity has come up occasionally in the past, and it's argued sometimes. In the present climate, clearly, that is a very important issue. It's in the present climate where a number of member states, not just the one I know best, are reviewing the allocation of competencies, possibly with a view to changing the allocation of competence. A matter which I think, by the way, is virtually impossible, but that's another debate altogether. I say that simply because the European Union is a dynamic community of law. It is not a static international organisation based on public international law with respect primarily for the sovereignty of states. It is impossible to draw a line in the sand and say so far and no further that the law will always evolve. Anyway, that's what I think about that. But there are certain provisions, like Article 4.2, that really were not intended to be subject to judicial interpretation. Of course, what the member states intend at a certain time is often thwarted by the fact that people go to court in member states courts refer, and the European Court, whether it likes it or not, has to take a view. But there are certain provisions, I think that's one of them, which frankly are political statements written by heads of state and government, which are not intended to be the subject of constitutional litigation as you would have in the United States. But, accidents happen all the time.
There were a couple of questions.
I didn't have a question.
Or a comment.
I had more like an observation from a country that's from Croatia. We just recently became a member. So it's quite, especially concerning human rights, let's say, it's quite hard to comprehend and to understand the application of European Union law, because, for example, I'm not sure how much do you know about when we basically entered European Union. Germany put arrest warrant on our citizen who made a murder in 17th in Germany, and we refused to give the
surrender
that citizen to Germany, because it was like it passed too many years. I don't know the term.
Retroactivity, anyway.
Prescription.
Time limitation. Yeah.
Time limitation.
Yeah.
Time limitation for the conviction. The crime was made in 70s during the Yugoslavia. It was connected to the politics then. The arrest warrant was brought before we. It was before we changed constitution. So there was a problem about applying arrest warrant. So it's not a question. It's just a position that we were put in. Is that this citizen has a right to expect time limit on his crime, but since at the moment we entered European Union, I think it's one of the basic human rights to the time limit, in courts where if you commit a crime, or every criminal law says in Croatia that you have a time limit in which you can be put in front of the court. I don't know if you understand.
I understand what you're saying. I think some colleagues from other jurisdictions may have a view on that. I'm not sure.
So the point is on murder, yeah. It was
a question, is it like a war crime?
War
So
crime.
there is no limitation or it's not, but till now Croatian legislation, it was not under that
Yes.
crime.
So
there is no
it's just an observation about human rights because it is a crime committed in the 70s. At the moment when we entered European Union, there was arrest warrant. So he was absolutely in no protection, legally expecting time limitation of his crime. It's just an observation, and Croatian courts
support the pressure of
support-
Germany.
yeah, we were under great pressure of Germany.
Political pressure.
But where was the crime committed?
Sorry?
In what country was the
In
crime
Germany.
committed?
Angela Merkel
So how
didn't
how
come.
could the defendant rely on Croatian law? When he committed the crime in Germany, he has to take the risk of
Yeah, but
German time prescription.
I don't know about that. But in a moment we entered European Union, they used the instrument that was lighter
Sure,
to
that's
them.
a transitional problem.
Yeah, there was 40 years in between.
It's funny, you
You
raise...
don't have to answer anything.
Does anyone here
Observation about
remember
human
the
rights.
Barber case?
Sorry?
There was a famous case that... this is a young guy, but he still remembers these things. It's amazing. Anyway, the Barber... The point I want to make is a very simple one. The courts, the national courts and the European courts are, what's the word I want to use, really? Uncontrollable. Can't control what the judges are going to decide. They're a living nuisance half the time, are the judges, politically, right? No. This is a debate, of course, which we've had in the United Kingdom for now 20 or 30 years, the fact that these foreign judges are taking these extraordinary decisions and imposing them on our sovereign country is an extraordinary thing. But of course, there is a very simple answer in the EU to how to control the evolution, or let's say a politically undesirable evolution of case law. Sorry, I'm making a broader point, right? And that is in the hands of the heads of state and government. If you don't like the judgment in case A, B, or C, fine. You bring in a treaty amendment and you deal with it. Because the ultimate sovereignty is in the hands of the European Council. Subject, of course, I guess, well, no, it's not subject to anything. It is a treaty signed by or ratified by the 28 member states is binding. That's it. And in the Barber case, the European Court of, and forgive me, it's advancing years. I've forgotten the details of the Barber case. The Barber case was a case about pensions, payments, yeah. I think it was, and the European Court of Justice had thought fit not to lay down any limitation on retroactivity. And the potential liability of the United Kingdom government or of the pension fund or whatever it was could amount to trillions of pounds or euros or whatever it was. And so the member states meeting in the European Council, or mini intergovernmental conference, introduced the Barber Amendment, whereby there was a limit introduced to retroactivity. So my point is, first of all, what you're saying is not new. The issue is not new. What the answer is, I don't know. I mean, probably, I know. But there is this problem or this issue in the eyes of some member states that the Court of Justice sometimes has gone further in a particular area than one would like. Think of, for example, benefits tourism. Think of that sort of thing. If you don't like it, change it. That's it.
There was also one slight problem with Croatia because we still weren't a member state. So at the moment it was like a week.
Yeah, you inherited a
no mechanism you can do it. It was like, oh, you're now a member state. Here's
bang,
arrest
yes.
warrant.
Oh, good. Yeah.
We had 2 arrest warrants. I'm supporting it because if someone did the crime,
You should
okay,
be, yeah.
you should have answered. But
Yeah, I
it's
see your
a
point.
bit strange position.
Can I
Yes.
ask you, I was going to ask a question before the Croatian speakers raised their point. It's a similar point. You discussed this case, I'm sorry, I don't know the name of it, the case where the Spanish court refused refused to comply with an Italian arrest warrant, yeah? Relying on Spanish constitutional law. And you persuaded me that the decision of the European Court was correct that you can't rely on national provision to defeat a European arrest warrant because of the primacy of Union law.
Not always. Maloney, though, is a very exceptional case. This is I mean, it's perhaps. I don't want to give the wrong impression. By and large, you can, and there are other cases where the court has allowed member states. Yes.
Is it, but you were suggesting as a matter of general principle that a national court, in applying European law, can give primacy to the Charter, right, to the fundamental freedoms in the Charter. Would it be possible, in your opinion, for a court faced with an arrest warrant, a European arrest warrant, to refuse to comply on the ground, for example, that the requesting state would expose the subject, the defendant, to inhuman and degrading treatment? Is that a possibility in the case of a European arrest warrant?
The European arrest warrant is a very particular instrument, and I'd be a little reluctant to start talking about. There are. I mean, I'm assuming that.
Of a European arrest warrant that makes it different from other European legislation.
Well, in the particular case, Maloney, what is interesting is that the particular point on which Spain had reservations had been dealt with in an amendment to the original framework directive. So in other words, you had, as it were, complete harmonisation as regards the problem of in absentia convictions. That's as regards the. I mean,
if it hadn't been dealt with specifically, would the decision have been different?
You could speculate the decision might have been different. Yes, you could, but it's a matter of speculation.
Well, that's by reference to a provision of the Spanish Constitution, not by reference to a provision of the Charter. I find that surprising.
Well, the Article 53 does allow member states, in most circumstances, to rely upon a higher standard, which is guaranteed a higher level of protection as protected under their constitution. And as I say, there have been a number of other cases. There's a recent case called F against the Prime Minister, where the particular person who was convicted or the subject of an arrest warrant complained that France had gone further than was required, and the court said it's okay. There's no problem with the effective judicial protection.
So if we
France
go to the Croatian case, forget about transitional provisions. Let's suppose this is a case which has occurred. All the facts have occurred after the Croatian accession to the European Union. Let's suppose that. Now, in this case, Croatia has a rule of human rights, which is, in fact, more protective than, let's say, some other states, such as the United Kingdom. We don't have a time limit for criminal actions. So, would you then take the view that Croatia would be entitled to refuse to comply with the European arrest warrant on the ground that under Croatian law, that's a breach of its human rights?
Again, it depends on what the framework decision on the European arrest warrant says. Possibly not, given the Maloney. As I say, the Maloney case is very specific, where a matter has been, as it were, completely harmonised for the purpose of point of view, the purposes of the application of the European arrest warrant. Then there mightn't be any room for the application of Article 53.
So in that case, if I understand you correctly, the same argument would apply to a requested state which refused to return on the ground of inhuman and degrading treatment. Because you would say it's also, this is a specific instrument which covers everything.
I really don't want to be drawn into specifics on the European arrest warrant. It wouldn't really be compatible with my function, if you don't mind. I did want to come back to two things that Alistair said, though, which are general and non-controversial.
First, to be controversial.
Well, as regards justiciability, you have to be very careful, because the court is not very willing to say that a particular matter is justiciable. What happens in practice is a matter is justiciable if the court is requested to deal with it. And as regards the principle of subsidiarity, for years, those member states which were most keen on bringing subsidiarity into the treaty then drew back when it came to actually applying for it. The first example, I think, was actually Germany, where they had a problem with a directive adopted shortly after the Maastricht Treaty came into force. And rather than saying that it was a breach of subsidiarity, they simply said that the legislature had not given sufficient reasons as to how the principle of subsidiarity had been respected. And therefore, if you like, it's a question of parties. Had the Court of Justice been requested to give a substantive ruling of subsidiarity, I have no particular doubt that it would have. And regarding the national identity, if I brought it up, it's because it was an issue in the Maloney case. The Spanish government suggested at the hearing that this aspect of protecting people who had been convicted in absentia was part of their national identity, and therefore it invited the Court of Justice to rule on what national identity means. And in fact, the Advocate General, in his opinion, did look at whether it complied, whether there was a problem for national identity. The Court of Justice didn't.
And of course, every single directive and regulation which is adopted by the European Union today contains reasoning on subsidiarity. Every single measure states, whereas, this matter is better dealt with at the level of the European Union than at national, regional or municipal level. So whether that's ever been properly considered, I'm not sure. It's like the impact assessment. Every single measure now is subject to an impact assessment. There is a committee in the Secretariat General of the Commission which looks at every measure on financial services, food law, you name it. They check it out to see what is the balance of interest. Is this going to create, is it excessive red tape? Will it cause costs to industry? Or will it benefit consumers and so on? It's a balancing it. And of course, you're absolutely right that if a member state doesn't like the reasoning, for example, because it loses in a qualified majority vote in the council, all it has to do is to go to the court, and the court would then have to decide whether that was correctly drafted or not.
Did you?
Yeah, if I can just shortly observe, I was writing before Croatian entered a European Union article about relationship between European law system and Croatian the national law systems, and then I write a system of principles from the treaties that determine that relationship. And it's obviously that from the start the court was that who made the principles making a wider jurisdiction of the European Union, like yesterday we said principle of primacy, they made a principle of direct effect, direct application, and so on. And from the other hand, there was always fight with, I feel it, with the governments who made in the treaties principles like principle of subsidiarity, proportionality. Now with the Lisbon Treaty, they made a principle for respect states. And they, Lisbon Treaty, they make a competence like this, like list, and before that was not the case. They have a very often invited on general clausula, and they made very broad interpretation. What are the jurisdiction of European Union for bringing the rules? You know what I'm trying to... This is a fight between court, who is developing European Union, and the member states who, in the political document treaties, making principles to stop that broader application.
I know very well what you're talking about, and it's the Court of Justice has been accused in not just the recent past, but the distant past, of being very activist, and as you say, extending the judicial reach or the competence of the court or the competence of the European Union in practice. That said, we're all lawyers. We all know that words on paper have less effect than actions, political actions. And as I always say, the main protection of the competence of the member states is not the treaty or the court. And all these provisions that have been brought in, as you say, the list of competences, it's useful. It's something that I hope clarifies things for the member states. At the same time, the actual competences of the European Union have been extended in an extraordinary fashion. Who does that? That's not the Court of Justice. That's the member states. The member states are the political authorities who have decided that certain matters should be dealt with partly or wholly at the European Union level. And at the same time, as I say, although the European Parliament has come up it has co-decision in certain matters, and all sorts of people have an impact in the decision-making process. Now the national parliaments have the right to show the European Union a yellow card or an orange card on the grounds of subsidiarity. It is still the member states who.
And also that checking subsidiarity and proportionality is now wider than was before. I want to say the member states also put it in the treaty.
Yeah.
They make it a wider control of also checking
To be fair, the principle of proportionality wasn't in the original treaties. That was something that was brought in by the Court of Justice. And just to add up something to what Alistair said, you weren't sure if it had been checked. Yes, indeed, there is case law to the effect that if the member states, or rather if the legislature doesn't show that it has examined the proportionality of a particular measure, that measure can then be struck down on that in that regard. I did want to say one thing also about the extent to which the member states and the political authorities, and particularly the member states, in fact, can overrule a judgment of the court. It is not as easy as all that. Because after all, once the Court of Justice has given a judgment, in order to change legislation, you'd think legislation would be easy, you need a proposal from the Commission. And given that the Commission and the Court are often ad idem on certain matters, they're relatively, as it were.
You don't need that for a treaty amendment.
No, I was coming to the treaty amendment. The treaty amendment is even more difficult in the sense that you need the absolute unanimity of the member states. And the problem, it's not a problem, but the fact is, in any particular ruling of the Court of Justice, you will find some parties are happy and some parties are not happy. Yeah. And therefore, it's as a practical proposition, it would be, I think, very difficult. I'm not saying it's impossible, and after all, you're quite right. They did manage to get unanimity on the Barber Protocol in, I suppose, the Maastricht Treaty in 1993. But that's highly exceptional. The fact of the matter is, when the court has spoken, it's really quite difficult to overturn it.
Yeah. We're going to stop for coffee. I know you're going to say that.
Exactly.
I'm going to just let me make a note orally here. I'm going to come back to this point in spades, as we say in English, with great emphasis when I talk about that dirty word beginning with T and ending in X, tax. We talk about tax. There's nothing closer to the sovereignty of member states than tax. There's no area where the European Court has been so dramatically inventive and judicially active as tax. On that stimulating remark.
Okay.